Welcome to the second last episode in this issue about land, chapter 300 of the Kenyan laws that deals with the land. Today, ask yourself, do you have children who are below 18 years? Have you bought property for them? Can your child have a title deed? Can a child who is below 18 years be registered as an owner of a title deed? It's a very serious question. I know most men don't want to register their land in the name of the wives. They want to register their names in the name of their children. I know most mothers, they don't trust, or most wives don't trust their husbands. They say, this one, he can marry another woman. If I die, I don't want my property to be in the hands of another woman or to be in the hands of another man. So what does the law talk about minors? The Land Registration Act, Cap 300, Section 47, has three critical fundamental questions about minors. I'll read them for the benefit of people not to say court helicopter manufactures them. Number one, the name of, that is 47.1, the name of a person under the age of 18 years may be entered in the register to enable the minor's interest to be held in trust and shall be registered under the name of the guardian, either on first registration or as transferee or on transmission. That is serious English. What does that law mean? The name of your child who is below 18 years will be registered in the title deed. But it will be registered together with an adult. That adult is a trustee of that minor. That is what the law says. That child of yours, your name will appear, but with an adult. The adult can be the uncle, the adult can be the mother, the adult can be the father, the adult can be his elder brother, somebody else. And the interest must be shown in the register. What does that mean? It must be the registrar will say, this land, Omari, an adult, is holding in trust for David Omari, a minor. That is an entry. Myself, I cannot sell that land because the land I'm holding in trust for a minor. So you get it very clearly. Number one, that is the name of your child will be entered, but the adult's name that appears there is appearing as a trustee holding the interest of the minor, and that interest must be put there. Number two, 47.2. Nothing in this section enables a person under 18 years of age to deal with the land or an interest in the land by virtue of such registration. And if the registrar knows a child has been registered, the registrar, listen, the registrar shall enter a restriction accordingly. Immediately, the name of a child has been entered into a title deed. The registrar puts a restriction immediately. We are going to deal shortly. What is a restriction? So the person cannot sell the land. The person who is an adult cannot take that land to bank to get a loan. That person who is put there as a trustee is restricted from disposing or selling or transferring that land. The law protects children. So don't say that children are not protected by the law. C, that is part 3, and this is very critical. If a disposition by a minor whose minority has not been disclosed to the registrar has been registered, that dispossession may not be set aside only on the grounds of minority. So if there was an accident and the registrar was not told the age of the child, that does not make that child lose the interest. That child only needs to produce a birth certificate and say, by this time I was 13 years. By this time I was 15 years. If the restriction was not put, the court will reverse or the land registrar will reverse. That is on part A, the minors. Court Helicopter News has protected the minors of this country and the minors worldwide, that don't allow your minor, your child, to be dispossessed. Don't register the property of your minor for another person for fear that if you die, the child will be dispossessed. Section 47 protects the minors. What about those who have disability? There are those ones who have children with the disability. There are adults who have mental capacities. There are people who cannot be assessed to be adult mind of sound mind. What does the law say? The registrar has power to register a guardian to execute the documents on behalf of this person. So, if you have somebody who is mentally ill, they cannot sign documents, you will go to court, get a guardianship order appointing you a guardian for the benefit of your sister who is disabled mentally, or for your brother, or for your child. That guardianship order, you take it to the registrar will allow you to sign the documents on behalf of that person who is a person who has that problem. Then section 49 asks, what happens when you want to give a gift to a child or to a person who is incapacitated? What happens? This is your child, you want to give land, but that child has incapacity. So, 49 says, a person with a legal incapacity who has been registered as a proprietor of land or a lease or a charge may repudiate the gift within 6 months after the person ceases to be under legal incapacity, if the person has not already disposed of the subject matter the transfer has been registered. What does the law say? If this land was registered with somebody who was at that time having capacity, later he develops legal incapacity because of medical reasons, you can apply to court for the court to allow you to have that power. 2, you can appear before the registrar within 6 months, and the registrar will deal with that matter before expiry of 6 months. So the question about that protector is not available for that. Then we have another issue, is the issue of when you take a property to the bank, what happens? Have you taken your motor vehicle to a Shylock and given a logbook and you have been given money? So we are dealing with what is called mortgages and charges. You take your title deed to the bank under Article 50, under Section 56, will give you money, but will charge your property. Remember, we talked about the section called encumbrances. In the title deed, that land was registered in your name alone. When you take money from the bank, you surrender the title deed to the bank. The title deed will be taken by the bank to the land registry. The title deed will be registered in two names, your name and the bank name. Your car will be registered in your name and the bank name. Until you finish payment, you cannot sell that property. You cannot transfer that property because that property is charged under section 56. If you take a further loan from a bank, you were given 5 million, the bank charged the property for 5 million, you wanted to pay dowry, you go there and they tell you dowry here is not 5 million, it's 7 million. Go and add 2 million. You go back to the bank and say, no, the people are marrying from 1 to 7 million. Add me 2 million. They will do what is called a further charge. They will do a second charge and it will be entered in the encumbrance section. So you'll have one charge of 5 million, you'll have another charge of another 2 million to pay dowry. Therefore, you cannot charge that land, you cannot deal with that land unless you are allowed by the bank to deal with that, because that mortgage and that charge is registered. You have now known. Wakili, Danstan Omari never gets stirred. Court helicopter news never gets stirred. They bring to you as the law, as it says. Next episode is the question, what happens when you are dead and the title deed is registered in your name and your husband? See you in the last episode. Thank you, Wakili Danstan Omari.